women, and that's not true.
I'm going to stop you here because you're trying to address the content of your case with me.
What do I do to address that? Do I get a lawyer and try to bring it back to court?
I can't give you advice on how you should proceed, and if you want to challenge this again, how you might be able to do that. You would need to contact an attorney and have them give you advice, because I can't give people legal advice because I'm the judge.
I just don't want to waste your time with trying to bring, the whole thing there.
Okay, I can't have you tell me the story because she hasn't been served with any notice of any hearing, and she's not here to be able to express her side of the situation. So
this whole thing revolves around the trespassing.
I appreciate that, sir.
Okay.
But I can't address the content of the case with you any further because she's not been given notice of this hearing. If you want to try to address the content of the case and challenge the order, you should go see an attorney and get some advice.
Okay.
For purposes of today, I am dismissing the order to show cause because, again, the personal protection order does not restrict any conduct on her part, and that's what this was about. So I will issue that order and we'll send you a copy in the mail. Okay.
Am I free to go?
Yes.
Thank you.
Ms. Underwood, you need to speak to Mr. Daniels.
Yes, please.
Okay, Mr. Daniels, if you can hear me, I sent a request to start your video on that device. Okay, there you are. And I'm sending a request to unmute that device. All right, this is file 24-21844-FH, People versus Robert Glenn Daniels. And we are here today for a hearing on an alleged probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record, please?
Rhonda Underwood for Mr. Daniels, Your Honor.
And sir, you're Robert Glenn Daniels?
Yes, sir.
Okay, Ms. Underwood, where are we with Mr. Daniels' situation?
Your Honor, I've checked with Mr. Daniels, and I believe his district court matters are just failure to pay tickets, Your Honor. So Mr. Daniels is prepared to take responsibility and enter a plea this morning, Your Honor.
Okay. Mr. Daniels, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Robert Glenn Daniels, correct?
Yes.
Mr. Daniels, do you understand you have a right to contest this violation of probation and to have a trial?
Yes.
Do you understand that throughout that trial you'd be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You'd have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions while they are under oath, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand that?
Yes.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you also have the right to testify if you wanted to testify. Do you understand that?
Yes.
How would you like to plead to the charge that you violated your probation by failing to report on June 3rd, 2025 or any time thereafter?
Is there a way I can have a little more time on this to plead?
Okay.
I'm just a little confused. I'm just not. I just would like to talk to my attorney a little bit more.
Okay. Ms. Underwood, do you want me to put you in a breakout session or?
Sure. Thank you. Thank you. Sorry.
All right, 1 second.
Oh,
Okay, this is file 24-51392-DS. Thomas Raymond Ruff versus Jessica Ann Ruff, and we are here today for arraignment on a bench warrant for failure to appear at a show cause hearing, and also a hearing on the underlying show cause for non-payment of child support. Miss, you are Jessica Ann Ruff.
yes, I am.
Ms. Ruff, have you received a copy of your bench warrant?
No.
Okay, we'll send a copy of that over to jail, so they'll bring you a copy. In the meantime, I will let you know that the warrant alleges that you failed to appear in court for a show cause hearing on March 2nd, 2026. The show cause hearing was for non-payment of child support. According to the information I have from the friend of the court, you don't have a monthly child support charge, but you do have an arrearage in the amount of $7,706.10. Do you understand, Ms. Ruff, that it is a crime to fail to pay child support to the best of your ability up to the amount ordered?
Yes, and I have been trying to get a job.
Okay, Ms. Ruff, I don't want you to say anything yet. I've got to ask you some questions to make sure you understand what your rights are. If you decide you want to say something after that, you can, okay?
Okay.
Do you understand that it's a crime to fail to appear in court when you've been ordered to appear?
Yes,
Do you understand that if you were to plead guilty or be found guilty of either of those offenses, the court could sentence you to jail for up to 45 days?
yes, Your Honor.
You are entitled to be represented by an attorney here today and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that, and I'll appoint one for you from the public defender's office. Do you understand that?
Yes, Your Honor.
Would you like to be represented by an attorney?
Yes, Your Honor.
Okay, do you have the ability to pay for your own attorney?
No.
Okay, if you wait there for a moment, I have to finish one hearing, and then I will appoint the public defender's office to represent you, and I'll have you speak to Ms. Underwood as soon as she's available.
Okay.
Ms. Underwood, have you received information from Ms. Ruff?
I believe I have, Your Honor.
Okay. Okay, we have Ms. Underwood and Mr. Ruff back from the breakout session now. Ms. Underwood, do you know how Mr. Daniels wants to proceed?
I believe he wishes to continue with the plea, Your Honor.
Okay. Mr. Daniels, do you understand that you don't have to testify at your trial and no one could say anything about you not testifying or hold that against you in any way? Oh, sorry, you were muted, sir. I'm going to send you a request to unmute.
Yes, sir.
And you also understand that you have the right to testify at the trial if you wanted to testify.
Yes, sir.
All right, so how do you plead then to the charge that you violated your probation by failing to report to your probation officer on June 3rd, 2025, or at any time thereafter?
Guilty.
And how do you wish to plead to the charge that you committed contempt of court by failing to appear at the hearing on the violation of probation summons on July 16, 2025?
What was that one? What is that for?
Failing to appear in court.
For
After you failed to report, Ms. Holly sent out a summons for a probation violation that set a court hearing.
Oh,
And the
yeah,
allegations with that court hearing.
Guilty, yes, guilty.
Okay. Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at the trial, as I've already explained to you?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No,
Has anybody threatened you in any way in order to get you to plead guilty?
no,
If I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
yes,
Is it your own choice to plead guilty today?
yes,
You were placed on probation in this case back in September of 2024. Is that correct?
yes,
Is it also correct that one of the conditions of your probation was that you had to report to Ms. Holly as directed by Ms. Holly?
yes,
And were you directed to report to her on June 3rd, 2025?
yes,
And did you in fact report to her on that day?
no,
Did you report to her at any time between June 3rd, 2025 and the day that you were picked up on this warrant?
no,
As a result of your not reporting, a summons for a probation violation hearing was issued. And you were required to appear in court on July 16, 2025 at 8:15 a.m. Do you agree with that?
yes,
And did you appear here in court on that day at that time?
no,
All right, I'll accept the pleas. They've been understandably, voluntarily, and accurately. Mr. Daniels has had full knowledge of his rights, and he's had competent counsel. I will refer this matter to the probation department for a probation violation review and set this sentencing on July 30th at 8:15 a.m.
Not until then, Your Honor.
Let's go with July 9th at 8:15.
Thank you, Your Honor.
All right, Mr. Daniels, you can let the officer with you know that you're done with court for today.
Thank you, Your Honor.
And Ms. Ruff, I'm going to place you in a breakout session with Ms. Underwood right now.
All right, thank you.
I apologize, Ms. Underwood. I clicked the wrong button on the breakout session, so let me try that again. All right, and Mr. Dagamar, are you ready to proceed with Mr. Dorsey?
Yes, Your Honor.
This is file 26-22597-FH, People versus Dante Devin Dorsey. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can you have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Your Honor, Michael Dagger Margosian for Mr. Dorsey.
And sir, you are Dante Devin Dorsey?
Yes, I am, sir.
Okay, Mr. Dagger Margosian, where are we with Mr. Dorsey's case?
Your Honor, Miss Arnold and I are still trying to work the case out. The OIC is on vacation right now, and I think his input obviously is going to affect how this case moves forward. And I believe that Miss Arnold still needs to speak with him. So maybe if we could adjourn this case until that can happen.
All right, Ms. Arnold, is there anything that you need to address?
No, thank you, Judge.
All right, I will adjourn this then to August 5th at 8:15 a.m. I think at that point, I'm going to be inclined to set it for a trial if there's not a resolution. At that point, this case is getting a little old.
Understood. Thank you, Judge.
Thanks, Judge.
Dante, did you receive my message that the courthouse is going to be closed Friday?
Yes, I did, sir.
Okay, I'll see you Monday at 9.
All right, thank you.
Okay, Mr. Dorsey, your next date is August 5th at 8:15. You can log in using all the same Zoom information that you used today.
Thank you, Judge.
Mr. Dagger-Margosian, would you do that stipulation in order?
I will.
Thank you. All right, we're all set then.
All right, thank you. Have a nice one.
Underwood and Ms. Ruff back from the breakout session now. Ms. Underwood, do you want to place your appearance on record?
Rhonda Underwood for Ms. Ruff this morning, Your Honor.
And do you know how Ms. Ruff would like to proceed today?
Your Honor, Ms. Ruff does not have a job. She's going back to Manpower on Monday, I believe, Your Honor. I know the court is interested in getting its money. Ms. Ruff doesn't have any currently. She does continue to reside at the address listed, Your Honor. She lives there. She's not running from anything. I would ask if the court would consider a PR bond to a week from Monday, Your Honor, by which time Ms. Ruff will hopefully present proof of employment, Your Honor.
Okay. Well, according to the information I have, she's already been arrested on this show cause once previously. There've been only 2 payments in the last 12 months. At this point, I'm not, we've got another failure to appear here at the last hearing. And so I'm not real confident that Ms. Ruff is going to appear in court or have a job by the next pretrial if I were to release her on a PR bond. So at this point, I don't think I'm willing to do that. I would be happy to set this for a hearing next Tuesday, which is when we have Mr. Brogan available to us if she'd like to do that.
That's fine, Your Honor.
All right, I will set this then for a evidentiary hearing on Tuesday, July 7th at 8:15 a.m.
Thank you, Your Honor.
Okay, Ms. Ruff, you can let the officer with you know that you're done with court for today.
So that means I'm staying in here
That is correct.
for just a week or the whole day? 30
Until
days.
next Tuesday when we have your trial.
All right, thank you.
Mr. Fry, do you need to speak to Mr. Bowie?
Yes, Your Honor.
Yes. Ms. Arwood, have you had any communication with Mr. DeVries?
Yes, he's in the MDOC, Your Honor.
Oh, yeah, I'm sorry. So we don't have MDOC logged in this morning with him. So we're going to have to adjourn Mr. DeVries and contact MDOC to get him here. Let's go with July 22nd at 8:15.
Your Honor, you said July 22nd?
Correct.
Okay, I'll make sure we get another writ out for that day.
Would you like me to prepare, or is it a step to adjourn?
The court will do the notice on that one.
Thank you.
Thank you. You had any communication, Ms. Underwood, with Mr. Jones?
Let me check, Your Honor. Thank you.
Okay. They have another info available for us.
Hello, it's Kelly again, Judge Alsters. If you can leave the room again, well, could we have Jacob forms above it? All right, thank you. Bye. Francis just emailed and said that it's not available on the site. His next date is the 21st. I said everything at the same time, thinking that he said something about that, but it wasn't positive. She sent me an email at the same time saying.
I did speak with him, Your Honor.
Okay, do you know where he is or why he's not here today?
I have no knowledge as to his whereabouts.
Okay. All right, this file 23-21615-FH and 23-21616-FH, People versus Maurice Leroy Jones. We are here today for a hearing on a probation violation in both of those files. And we are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearance on the record? Ms. Arnold, are you appearing on this?
I am Allison Arnold for the people.
Rhonda knew it for Mr. Jones this morning.
The record should reflect this matter was set for hearing this morning at 8:15 a.m. It is now 9:12 a.m. Mr. Jones is not present in the courtroom and he is not logged into the Zoom session. I've identified everyone that's been in the Zoom waiting room this morning and Mr. Jones has never been present. Ms. Underwood, is there anything you want to say with respect to Mr. Jones at this point?
I have no knowledge as to his whereabouts, Your Honor. I know he lives in Detroit. I talked to him. It was not my impression he was not going to be here.
All right, I am going to, based on his failure to appear this morning, issue a bench warrant. And I'm going to set bond on the bench warrant in the amount of $5,000 cash or surety in each file.
Is there any hold on that bench warrant, Your Honor? I would if we could perhaps hold that until a 48-hour hold.
I don't see any prior failures to appear in Mr. Jones' files, so I will hold that bench warrant for 48 hours if we haven't heard from Mr. Jones within 48 hours, then I will issue those bench warrants.
Thank you, Your Honor.
And call for I've got 2 booths in there.
Hopefully, and a little bit of downstairs or wherever. New restaurant, right? They're different from the other ones.
Mr. Boone's upstairs. Yeah, actually. Yeah, I guess you can try if you want to call for Ricky Silva. We can try that.
Kelly, can I just could we have Ricky Silva in the room, judge, please? Thank you. Bye. Nice. He has an 8:15 trial with Judge Olsey this morning versus Johnny Tompkins. No, his client is on Zoom. We have not seen him yet this morning on Zoom. Okay, very good. Okay, thank you. Bye-bye.
Sir Moore, do you need to speak to Mr. Tompkins?
No, Your Honor, we have spoken and Mr. Bayonetto and I have spoken, so we're ready for a plea this morning.
Okay. This is file 26-22616-FH, People of the State of Michigan versus Johnny Tompkins. We are here today for a pretrial conference in this case. We're proceeding today by video conference First, can I have the attorneys place their appearance on the record, beginning with Mr. Bandit?
Alex Baynetto for the people.
Your Honor, Elias Muad appearing on behalf of Mr. Tompkins. I'm just moving to a quieter place.
Okay, and sir, you are Johnny Tompkins?
Yes.
All right, Mr. Muad, where do we stand with the case today?
So Judge, my client is going to be pleading guilty to the count and only count one. There is a 771.1 recommendation. The restitution is a little over 34,000. Mr. Baynetto will put that on the record. At the time of sentencing, this is not part of the agreement, but if he does pay the restitution prior to sentencing, I may talk to the court about some lesser probation, but that can wait till sentencing. But otherwise, he's pleading straight up with the 771.1 and a dismissal at the end of that, Judge.
Okay, Mr. Baynetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor. The exact amount of the restitution is $34,000 or $34,453.37. And Your Honor, speaking with Mr. Muad, if the defendant does not pay that amount of restitution throughout the life of his probation, then the case would not be dismissed at the end. But everything else Mr. Muad put on the record was accurate.
Yep, that is accurate, Your Honor. And Mr. Tompkins knows that.
Okay, Mr. Tompkins, will you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Johnny Blaine Tompkins, correct?
Yes.
Mr. Tompkins, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, a non-sufficient funds check of $500 or more?
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 2 years in prison and or a fine that's the greater of $2,000 or 3 times the amount that was payable on that check?
I did not, but I do now.
Okay. You can put your hand down if you like.
All right.
Are you satisfied with Mr. Muad and the advice that he's given?
Yeah.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as we've discussed on the record here today. Is that correct, Mr. Baynetto?
That's correct, Your Honor.
Mr. Muad?
There's no background noise, but that is correct what you just said.
Okay, is that also your understanding, Mr. Tompkins?
Yes.
Mr. Tompkins, if a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. You also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Tompkins, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes,
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
yes,
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you, Mr. Tompkins?
no,
Do you understand that you're giving those rights up?
yes.
How do you wish to plead to the charge that on or about January 19, 2026, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of non-sufficient funds check of $500 or more?
I'm guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge, Mr. Tompkins?
No,
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea?
yes,
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than this plea bargain to induce Mr. Tompkins to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Tompkins, other than as we've discussed it on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
no,
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
yes.
Is it your own choice to plead guilty today?
Yeah,
Okay, Mr. Mawad, do you want to establish the factual basis?
Judge, I think Mr. Bayonetto was going to do that when I talked to him this morning. He knows a little bit more about the restitution and how it was equated. If that's up, I think Mr. Bayonetto is going to establish that.
I
Okay.
can, Your Honor. Mr. Tompkins, on January 19th of 2026, did you present two checks to Eric Anderson totaling $65,000?
yes,
And the payee on those checks was Autos Unlimited, which was Mr. Anderson's business, correct?
yeah,
And that those checks were presented in the city of Adrian, County of Lenawee.
yep,
And at the time that you wrote those checks to Mr. Anderson, you did not have $65,000 to cover the checks in your account. Is that correct?
that is correct.
And the bank that you were drawing the checks from was TLC Community Credit Union.
That is correct.
And at the time, you knew you did not have $65,000 in your account to cover those checks.
Yeah,
And those checks were presented to Mr. Anderson with the intent to defraud him of that money, correct?
no, he was going to hold on to them, but he didn't. So that's my fault for not.
Mr. Mawad, you're muted.
Mr. Tompkins, in order for the judge to accept the plea, this is part of the elements. So the
Okay.
fact that you knew that there was an NSF check that you were handing him, you knew
Yeah.
you didn't have the money, you intended to defraud him because even though maybe you were thinking something else, you did intend to defraud him because you knew the money was not in the account.
Okay.
Correct?
Yeah.
Yes? All right. Mr. Bayonetto, if that satisfies him, the judge, I think he's answered it.
I'm satisfied for the elements. And Mr. Tompkins, the only thing I want to ensure for the record, you would agree that the restitution in this case was calculated at $34,453.37.
Yeah, that's what you had mentioned. Yes.
Yes. And Your Honor, just so the record is clear, that one check for $40,000 was presented for payment for vehicles. When that check bounced, Mr. Anderson had to sell the vehicles to somebody else, but took a almost $10,000 loss. That's where the difference in the money comes in, and how the restitution is equated to that $34,000 number. But I believe that does satisfy all the elements, if Mr. Mawad is satisfied.
Okay, has the court complied with MCR 6.302 B, C, and D, Mr. Banetto?
It has, Your Honor.
Mr. Mawad?
You have, Your Honor. I'm not sure if you heard me. I'm sorry.
Okay. All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Tompkins has had full knowledge of his rights, and he's had. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for August 6th at 8:15 a.m. I guess sentencing, for lack of a better word, I understand it's a delayed sentence. So at that point, I would just include the supervision terms and set a new sentencing date for approximately 12 months out.
Judge, would you mind going one more week past that? I'm going to be in a trial in Livingston County on the 4th. It's going to be a full week trial.
Okay, so next week is not available, so we'd have to do August 20th.
Okay, that's fine. And I think I was going to ask for a little bit more time anyway. So hopefully, John, will pay off the restitution and we have a lot more good news, Tompkins.
All right, so Mr. Tompkins, your next date is August 20th at 8:15 a.m.
Is that Zoom, sir?
That can be by Zoom if you prefer, yes.
Okay.
All right, you can go ahead and log out.
Did you say this is a delayed sentence? Is there no PSI? Is Mr. Coast having to supervise him?
Yes, Mr. Coast would be supervising.
Okay.
For the period of the delay. Yeah, sorry.
Okay.
Thank you. Thank you. Gentlemen, talking to you.
Okay, thank you, Mr. Mawad. All right, Mr. Fry, you ready to proceed with Mr. Bowie?
Yes, Your Honor.
Okay. This is file 25-22321-FH People versus Marcus Anthony Bowie. We are here today for an arraignment on a bench warrant in this case. We are proceeding today by video conference. Sir, you are Marcus Anthony Bowie?
Correct.
Sir Bowie, have you received a copy of your warrant?
No, I did not.
All right, we will contact the jail and have them bring you a copy of it so you can see that. In the meantime, I will let you know that the warrant alleges that you failed to appear at a final pretrial conference on May 13, 2026 at 8:15 a.m. If you were to plead or be found guilty of that, it's considered a contempt of court. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. Mr. Fry already represents you on the underlying action, and do you want him to represent you with respect to the contempt as well?
Yes, please.
All right. Well, I guess first let me have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people. Brian Fry for Marcus Bowie.
Mr. Fry, do you know how Mr. Bowie wants to proceed with respect to the failure to appear?
Yeah, Your Honor, I did talk to Mr. Bowie. My understanding is that he just wants to admit to that.
Okay, Mr. Boyd, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
Do you understand that you have a right to contest the contempt of court and have a trial on it?
Yes.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, I understand.
You'd have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand that?
Yes, sir.
You would not be required to testify at your trial, and no one could say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you'd also have the right to testify if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you committed contempt of court by failing to appear at the final pretrial on May 13, 2026 at 8:15 a.m.?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've just explained to you?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Have you been threatened in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes, it is, sir.
So you had this matter pending. We had a number of pre-trials, and ultimately we set a trial date and a final pre-trial conference for May 13, 2026 at 8:15 a.m. Is that correct?
Correct.
And you did not, in fact, appear in court or log into Zoom on that date. Is that also correct?
Correct.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Bowie has had full knowledge of his rights, and he has had competent counsel. Mr. Fry, where do we stand on the underlying case?
Yes, Your Honor, we would be asking for that to be reset for trial.
All right, and we had that set for 2 days. Ms. Clark, can you give us a 2-day jury trial date, please? Ms. Clark, are you there?
Oh, sorry, you didn't hear me. Thursday, September 24th at 9 and Friday, September 25th at 9, backed up to a jury trial.
Your Honor, my issue with having it as a backup is that I believe 3 of our witnesses live in the Muskegon area. And so I think it would be best to have a firm date so they know that, when they take off work, they can appear and testify.
Okay, do you have any issue with that, Mr. Fry?
Yeah, I don't, not necessarily. I don't know what time difference we're talking about, but I mean, obviously, having a primary is always better.
What do we have in terms of a firm date, Ms. Clark?
You do Tuesday, December 15th at 9, Wednesday, December 16th at 10:30, and Thursday, December 17th at 9.
That's good for the people.
I'm available.
to a final pretrial then on December 2nd at 8:15 a.m. Mr. Fry, did Mr. Bowie want to proceed with sentencing now on the contempt, or how does he want to handle that?
Yeah, we can just proceed today, Your Honor.
All right. Is there anything you want to say on behalf of Mr. Bowie with respect to the contempt before the court passes sentence?
Your Honor, Mr. Bowie has taken responsibility for his failure to appear. I would note that this case had been going through the courts for a good amount of time in district court and circuit court, and Mr. Bowie had appeared prior to this, and frankly, he'd been engaged with my office too regarding the trial. So, I was a little surprised when he didn't appear, because he was one of more engaged, client, of mine, who was taking an active part in his case and appearing to court. My understanding is that there was a new charge in district court that, might have contributed to his not appearing. Not an excuse, but I think he will be attending going forward, Your Honor, and has taken responsibility for his actions, and will be participating in his case and is eager to get this resolved. So we'd ask the court to take that in consideration when deciding what would be an appropriate sentence in this matter. Thank you.
Mr. Bowie, is there anything you want to say on your own behalf before the court passes sentence?
Yeah, basically like the same thing that my attorney said. I'd just like to piggyback off that, and apologize for, wasting the time of the court. And that's about it.
Okay, so all failures to appear are disruptive to the court trying to get its work done. In this case, the failure to appear caused the cancellation of a trial, which is particularly disruptive, because when we set those dates aside for people, we have to tell other people that they have to wait to get into court. And in this case, people had to wait to get into court for a trial that had to be canceled because Mr. Bowie didn't appear. So I do think there needs to be a consequence for that. It is going to be the sentence of the court that Mr. Bowie served 60 days in the Lenawee County Jail with credit for 1 day served. Following the service of that jail sentence, he can be released on a PR bond with a GPS tether, which I think at this point is necessary so that we know where he is, so that we don't have to go through this again in December when the trial date comes around. All right, the court will issue a scheduling order. Is there anything else we need to address in the case today?
No, thank you.
All right, Mr. Bowie, you can let the officer with you know that you're done with court for today.
Okay, Your Honor, may I speak to my attorney one more time before I get out of here?
Yes.
All right.
Second.
Thank you.
Okay, I have a jail Zoom device, a device that's labeled jail Zoom, and a device that's labeled jail Zoom 1. I've sent both of those a request to turn the video on. If there's anyone in either of those rooms, please turn the video on.
Do you know which one?
There's one labeled.
Because we have Jacob Forbes in one, we have Ricky Soto in one.
I have.
Okay.
They have logged in. They need to send help.
Do you know? The jail's in two, there's nobody in it. The judge said it's one that there's no, that it's muted. So there's no.
Camera's off and it's muted.
Said that there's no, he said there's another one that the camera's off and it's muted. So I don't know if it's your floor. We don't know. No, because Bowie is talking with his client or talking with his attorney in one. We asked for Jacob Forbes Lovett in one, and then we asked for Ricky Soto in one, so I don't know which one is which.
Ricky Soto is already in there, right?
I didn't even talk.
So you just, I guess I'm confused. You want me to close the ones that are not being, the computers are not?
Where you're at right now, we need Ricky Soto. Do you?
Yeah, he's in there. He's not.
You don't see him?
No.
We don't see him.
I mean, he was just talking to you from an empty room. If there's another device that, another room that Ricky Soto is in, they need to turn the camera on. That.
There he is. There we go.
Okay.
He just, we didn't click. Here we go. Yep.
Bye.
Okay, Ms. Underwood, you need to speak to Mr. Soto.
Yes, I do, Your Honor. Thank you.
Mr. Soto, I've sent a request to transfer that device to a breakout session. If you click yes or join or accept or whatever it's asking you to do, please do that.
I don't understand you, Your Honor.
Hi, it's Kelly again with the justices. The volume of the list needs to be turned down. It's very loud.
I understand what you're saying.
Michigan versus Ricky Gomez Soto. We are here today for a pretrial conference. In this case, we're proceeding today by video conference. First, can you have the attorneys place their appearance on the record?
Alex Bayanetto for the people.
Rhonda, do it for Mr. Soto, Your Honor.
And sir, you are Ricky Gomez Soto?
Yes, Your Honor. Good morning.
Ms. Underwood, where do we stand with Mr. Soto's case today?
Your Honor, the first thing I would like to address is a bond issue, Your Honor. Mr. Soto is in jail on a violation of the bond conditions allegation that he had contact with the victim by taking her cigarettes at the adult foster care where she was. Mr. Soto, prior to that, Your Honor, was successfully allowed to go across to leave jail and to go across the street to his bank to get money for the tether involved. The prosecution in this case now wants 2 tethers before Mr. Soto is given a PR bond. I would ask, under the supervision of Mr. Coast, if Mr. And he was successful at that, Your Honor, he completed that. He did that and returned appropriately and got the tether. I would ask if this court would allow him to do the same under the auspices of Mr. Coast, Your Honor, so that Mr. Soto can be released on a PR bond, and this case can proceed forward accordingly, Your Honor. I believe that presents no danger to the community. I don't believe Mr. Soto is any threat to go anywhere but across the street to get the money and have the tethers, both tethers put on, Your Honor. I would ask the court for that lenience on Mr. Soto's behalf.
All right, Mr. Van.
Your Honor, I would strenuously object to any bond modification at this point. This is now the 5th time that Mr. Soto's bond will have been reviewed in this case. Mr. Soto has 7 prior domestic violence convictions. He was, at the start of the case, after the no contact order was placed, during one of the bond hearings, he was admitting, or not admitting, he was stating things about the whereabouts of the victim and things that he could not have known had he not have been in contact with the victim. And I expressed my concerns at the original bond hearing. Fast forward, he is eventually released on a alcohol tether, and Ms. Underwood is correct that he did get that put on. However, the day he was released is when he began going to see the victim again. 3 separate days, he goes to her adult foster care home, repeatedly violates the no contact order, is eventually taken back into custody for that violation, as well as confirmed tampering with his ankle monitor. And during the bond hearing in that issue, Mr. Soto, on record, admitted he had been putting a sock between his ankle monitor and leg. So the ankle monitor would not have been able to pick up whether or not he had been drinking. Mr. Soto has a very, very long history of alcohol problems. I've indicated to Ms. Underwood I wouldn't object to him being released with the tether and the scram unit, but Ms. Underwood has indicated Mr. Soto can't afford those. I think anything lesser would not is just wholly inappropriate in this case. Mr. Soto's lengthy violent criminal history and repeated violation of this court's orders throughout the life of this case should actually be an increase in bond, not a decrease in his bond. So, Your Honor, I would object to modifying his bond at this point. I think as it stands now, it's total bond of $5,000 with a scram unit and an ankle monitor to monitor his location. I think given Mr. Soto's lengthy criminal history, that's absolutely appropriate, and I would ask that the court not modify bond at this time.
I would say, Your Honor, I believe if Mr. Soto can get to his money, he can both bond out and get the scram units, Your Honor, and the other tether. Mr. Soto, Your Honor, just as he did last time, would go across the street and get his money. That is what Mr. Soto wants to do. Your Honor, Mr. Soto, since Mr. Bayonetto can, any allegation of tampering was because Mr. Soto had an incision on his leg, Your Honor, and I believe, and would seek relief from that, rubbing against it at times. Your Honor, I don't believe at this point Mr. Soto is a danger to anyone, and he's certainly not a danger to flee with
Well,
and the ankle monitor. If the court does not want to modify the amount of bond, Your Honor, then I would hope the court would at least allow Mr. Soto out to get the money to pay these things, Your Honor.
Mr. Soto's history belies your belief that he is not a danger to anyone. He has, looking at the file, 7 prior convictions for domestic violence. He's charged in this case with domestic violence, and he has a pending contempt apparently for having contact with the victim in this case while he was out on bond. So I appreciate that you want to see the good and believe that he'll be good this time, but nothing about that history suggests that. And so I'm not doing my job unless I set a bond that is appropriately protective of society, and particularly protective of the alleged victim in this case. I think that bond is appropriately set in this case. I think it's reasonable given the circumstances. And frankly, given the circumstances as I know them, if I were going to make a change, I would be more inclined to increase it than to allow further accommodations. And so I'm not going to allow Mr. Gomez to leave the jail absent the tether and the scram and the bond being posted. So if you want to set hearings on the pending contempts, we can do that. If you want to set a trial date, we can do that. You know, we can move his case forward, but the bond situation is going to remain as it is.
Thank you, Your Honor. Well, then we'll set a pretrial as soon as possible, but I'd like, I guess, then a trial date.
Sir Bayonetto, how much time do you need for a trial in this case?
Your Honor, I think I can probably wrap it up in one day. I only have, I think maybe 4 witnesses I would need.
Ms. Underwood, do you agree that 1 day would be sufficient?
Sure, Your Honor.
I'm sorry, I didn't understand what you said.
Yes, Your Honor.
Okay. Ms. Clark, can we have a 1-day jury trial date, please?
Thursday, August 27th at 9 a.m.
That works for the people.
That's fine, Your Honor.
August 27th at 9 a.m. will be the trial date. Let's do a final pretrial on August 19th. And Ms. Underwood, do you want a pretrial between then and now?
Yes, please, Your Honor.
Let's go with July 15th.
Thank you, Your Honor.
Okay, the court will issue a scheduling order.
Mr. Underwood? Your Honor?
Mr. Soto, you can let the officer with you know that you're done with court for today.
Will I be getting my PR bond?
Your bond is not changing, Mr. Soto.
Now, I'd like to go to the police station so I can register and pay my fines.
Mr. Soto, your bond condition is not changing. You can let the officer with you know that you're done with court for today.
All right, Your Honor. Thank you.
I think that wraps up the court's docket for today.
Hang on. No, I've still got an arraignment on Mr. McDuffie for Judge Ansel.
Oh, okay. I will hang out for that then.
All right. So this is file 26-22680-FH, People of the State of Michigan versus Nolan Anthony McDuffie Jr. We are here today for an arraignment. In this case, we're proceeding today by video conference. Courtroom is open to the public. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Brian Fry for Nolan McDuffie.
And the record should reflect this matter was set for a hearing this morning at 8:15 a.m. It's now 10:04 a.m. Mr. McDuffie is not present in the courtroom, and he is not logged into the Zoom session. He has not been logged into the Zoom session at any point this morning. Mr. Fry, is there anything you want to say about Mr. McDuffie?
Your Honor, I don't know where Mr. McDuffie would be. I would say he has appeared in the past. He has been in touch with my office. I have talked to him last week. He's also wearing a tethered GPS monitor right now. So, I mean, his whereabouts should be known, wherever his location may be currently. I tried to reach him this morning when I learned that he was not logged in or at the courthouse, but I have been unable to reach him this morning. So I'm not quite sure what the issue is, Your Honor, but I will say over the last since we had court in district court, since this was bound over, he has reached out to my office multiple times and came in person one time. So I'm not quite sure why he wouldn't be here today. We'd be asking the court consider setting this over to a new date. Thank you.
Mr. Bayoneto?
Your Honor, the defendant has a pretty significant criminal history, and that coupled with the fact that he does not have ties to the area and he does live, I believe, in Detroit. I think a bench warrant would be appropriate in the case. I wouldn't have any objection if the court wants to hold it for 48 hours in case it was just an oversight and he wants to reach out to Mr. Fry. But I think a bench warrant is appropriate in this case, and I'd ask that the court order it at this time.
Okay, Mr. McDuffie does have an habitual offender notice convictions for attempted delivery manufacture of a controlled substance, and 2 convictions for sorry, 1 conviction for delivery manufacture of a controlled substance. Another controlled substance conviction after that. He's charged here with 2 counts of delivery or manufacture of a controlled substance less than 50 grams and maintaining a drug house. He has failed to appear here today. I will allow the 48-hour grace period if we have not heard from Mr. McDuffie within that 48-hour grace period. I will issue bench warrant at that time, and we'll set bond on that bench warrant in the amount of $25,000 cash or surety, again with the GPS tether.
Thank you, Your Honor.
Okay, I think we're all set on that one, and then can you call them? I still have Mr. Forbes. Love it. Daily Barron's the last one.
Yes. Thank you. Bye.
Sorry, Your Honor, I wasn't tracking the docket this morning because Mr. Sneed was on. Is there anything else that you need our office for?
No, the only other 2 I've got this are bench warrants.
Okay, have a good day.
Bailey Barron. Bailey Chris. Okay. All right, thank you. Bye.
Good morning, sir. What is your name?
Jacob. Forbes Lovett.
Okay. This is file 25-22219-FH People of the State of Michigan versus Jacob Valentino Forbes Lovett. We are here today for arraignment on a bench warrant, in this case for failure to appear at a violation of probation summons. We are proceeding today by video conference. Sir, you are Jacob Valentino Forbes Lovett?
Yes, Your Honor.
Mr. Forbes Lovett, have you received a copy of your warrant?
I believe so.
All right. The warrant alleges that you failed to appear for a violation of probation summons on April 1st, 2026 at 8:15 a.m. The violation of probation summons alleged that you violated your probation by failing to pay anything towards your court costs by consuming alcoholic intoxicants and testing positive on March 9, 2026 while reporting to the Monroe District Court treatment probation, admitting that you had been continuing to drink at least twice a week since 2024, and by using illegal controlled substances, specifically cocaine and THC, testing positive on March 9, 2026, while you were reporting and admitting that use. You had pled guilty in this case to 1 count of reckless driving and 1 count of 4th degree fleeing and eluding. And the maximum possible penalty for the reckless driving offense is up to 93 days in jail and or a fine of $500. The maximum possible penalty for the 4th degree fleeing and eluding is up to 2 years in prison and or a $500 fine. You are entitled to be represented by an attorney today and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office at no cost to you. Do you understand that?
Yes, Your Honor.
Do you want to be represented by an attorney today?
Yes, Your Honor.
Do you have the ability to pay for your own attorney?
Yes, I just need to make a phone call.
Okay. Do you have an attorney that you want to represent you?
Yeah, I had an attorney that I use.
Who is that? Do you know?
I can't remember his name now, top of my head. If I can make a phone call, I can figure it out. I do want to say though that
Okay, I don't want you to say anything. I don't want you to say anything before you speak to your attorney, because anything you say could compromise your position. Okay.
Okay.
All right. So here's what I'm going to do. I will adjourn this to either. I'm going to adjourn this to tomorrow morning at 8 a.m. If they'll let you make a phone call at the jail, you can call your attorney. If your attorney calls us and we can get you back on the record here yet today, we'll do that. If you have trouble making a phone call out of the jail to your attorney, if you just have the jail contact the court with your attorney's name, we'll get in touch with that person and see if we can get them arranged to see you today.
Thank you.
The pre-sentence report said that it was Leslie Icott. I don't know if that's who I was thinking about.
Yes, thank you.
Okay. Ms. Holly, could you email that name to either myself or Francis, and we'll try to track that person down.
Okay.
Okay. All right. So, Mr. Forbes Lovett, you can let the officer with you know you're done with court for now. And if we can, as soon as we get in touch with your attorney, we'll get you back on the record.
Thank you, Your Honor.
You are Mr. Barron?
Yes, sir.
Okay.
What would you do if you walked into court 2 hours late, only to have the judge reveal that you had 18 outstanding warrants? That's exactly what happened in this unforgettable courtroom moment. The defendant casually walked into the courtroom long after his hearing was supposed to begin. The judge immediately asked why he was so late. The defendant blamed a long night at work, but the explanation didn't impress the court. Instead, the judge looked directly at him and asked a question that instantly changed the mood of the courtroom. Do you know how many warrants you have? The defendant quietly admitted he didn't know. That's when the judge began counting them, one by one. 1, 2, 3, all the way to 18. With every number, the seriousness of the situation became more obvious. The courtroom fell silent as the defendant realized just how much legal trouble he was actually facing. The judge didn't stop there. He explained that repeatedly missing court dates doesn't just waste the court's time, it destroys a defendant's credibility. Looking directly at him, the judge asked, "What would you think if I showed up 2 hours late to court?" The defendant admitted it wouldn't be acceptable. The judge responded by saying the same standard applies to everyone who enters a courtroom. Judges, attorneys, court staff, and What happens when a defense attorney challenges almost every piece of evidence in a DUI case, but the judge still refuses to throw the case out? That's exactly what happened in this courtroom. The hearing focused on a motion to suppress evidence, where the defense argued that the traffic stop should never have happened in the first place. If the judge agreed, much of the prosecution's evidence could have been excluded before trial even began. The defense started by questioning the deputy's observations. They pointed out that the driver wasn't weaving, drifting between lanes, or driving erratically. In fact, the deputy admitted that aside from speeding, he observed no classic signs of impaired driving before initiating the traffic stop. Then the attorney challenged the speeding allegation itself. The deputy acknowledged he wasn't using radar to measure the vehicle's speed. Instead, he relied on his own observations and experience. The defense argued that without radar or another reliable measurement, there wasn't enough evidence to justify stopping the truck. But that was only the beginning. The defense also questioned nearly every field sobriety test. They reminded the court that sober people can sometimes fail these tests, that environmental conditions can affect performance, and that flashing patrol lights, fatigue, balance issues, and even footwear could influence the results. The attorney even argued that having glassy eyes, smelling like alcohol, or having an empty beer box inside a vehicle doesn't automatically prove someone is legally intoxicated. After all, drinking alcohol isn't illegal. Driving while impaired is. Next came the issue of the blood test. The defense argued that the investigation contained several weaknesses and questioned whether there was enough